Make that 17 minutes away from the top of the hour. Weatherman predicts we're going to go up to 31, 32 degrees. Right now, it's currently at a high point. It is 31 degrees. It feels like 37 degrees. Whew. It's going to be a hot and scorching one. All right. You know what we've been talking about. By the way, we'll be joined this morning by Nicole Dyer-Griffith. She will be joining us. We'll also be joined by Michael Seals. Okay, two of our guests coming up. But this gentleman is going to cover an area to me that is a sore thumb. I called him because it is part of the area of his expertise. And I said, man, have you seen this? And he said, yeah. Well, why are you so surprised? And I said to him, well, look, we got to talk about this because I am currently in a spot. I called him from where I was. I said, I'm in a spot where I see something that says we are not responsible for injury to you or your property when you park in this location. And I said, well, no, it's not repeatable. Anyway, I called him. He is attorney Christopher Forde, and I asked him to come in this morning. Mr. Forde, thank you so much for coming in.
Thank you very much for having me, Mr. Bishop.
It's good to have you here again. You're no stranger here, immaculately dressed, by the way. I should just say that. So this area of me going to patronize a business,
yes,
and the business basically saying you're on your own once you pull into my property, and I'm not parking on the street now. I'm pulling into the property of this business, and I'm parking there,
yes,
and I'm going into shop, and I meet this sign that says to me, we're not responsible for injury to your property, which is usually, or in this case, we're not responsible for injury to you or your property. Is there something legal about this? I mean, to me, it strikes me the wrong way. This could not be legal, I said.
Well, Mr. Bishop, when we speak about liability and ascribing liability,
yes,
in order to do so, a man must first have some responsibility for you or over you.
Yes.
Right? They must have some kind of duty of care for you. Now, in terms of a contractual relationship, you go to purchase something from someone. The question is, what are the terms of your contract with that person? Even so, that relationship also raises raises a duty of care on behalf of the provider. Now, when they provide their service, if they invite you onto their property, now it arises, like I said, duty of care arises. Now they have an opportunity to indicate to you the duty that they assume over you and over your personal items. So if at the time when you are entering into a relationship with them, they indicate to you, well, I know I have a duty of care towards you, but it's limited to this extent, and you know that, then it's perfectly legal. At the end of the day, when it comes to contractual relationships or even negligence, it's a question of what duty did I assume for you.
So I enter the premises of a business, okay?
Yes.
I assume that business is insured, yes. I assume the compound on which that company doing their business is insured. You were telling me that if I park my vehicle on their property, that I am not insured. Is that what you're saying to me?
Well,
that disclaimer has said to me,
yes,
this place is not safe. You park at your own risk.
Well, what the disclaimer says to you is that when you're parking here, when you're using my services, I only hold myself liable to this extent. Or
I like the way you do it, Mr. Attorney. I like the way you do it, Mr. Attorney. What it says is, you are coming to spend your money with me.
Yes.
And while you're doing that and you park on my property, I am not responsible for whatever happens to your property. And they're not just your service. Yes, you are a grocery and you're going to sell me the goods, yes, but I am coming into your enclave, as it were. Yes. I am in your parking space. I am coming here to do business with you. Otherwise, you will have me towed. You're telling me that when I come to patronize you, I have no rights for my vehicle.
Well, what the person is saying to you is this: listen, I am providing a service to you. Yes, I'm providing parking services, but at the end of the day, it's limited to this extent. Now, you have to understand, when we do business with people, they assume certain liabilities, right? Now, if they don't say that, then they may be held liable for that. So they have to let you know in advance what they are not liable to. So you have a choice.
I walk in there and my vehicle is damaged. Forget about what the signs say. Can I go to court and say I am demanding compensation, and is the court going to look at me and say, like, did you see the sign, or is there some legislation that gives me a case for compensation?
Well, it depends. Now, first of all, if you saw the sign at the time when you drove in,
Yes.
then you were aware that they wouldn't have hold themselves liability. They put an exclusion clause there. And no, I don't think the court would necessarily grant you your relief. No, it all depends. There is the Unfair Contract Terms Act, which provides that when it comes to personal property, that the exclusion clause will only be valid if it's considered to be reasonable.
This is what do you call this?
The Unfair
Contract
Terms
Clause.
Act. Now, let me say Unfair Contract Terms Act. Yes. Now, let me say, first of all, they cannot exclude themselves for liability for personal injury. A lot of places have up signs that says, if you hurt yourself here, we are not liable for any personal injury.
I'm coming there. I'm coming there, all right.
They can't do that.
I just want to deal with my car right now, my property.
Yeah, well, I understand. Okay, but as far as the property is concerned, the court would look at whether or not it's reasonable. They will look at all these circumstances. I mean, I can't give you a definitive answer.
Okay.
It all depends on what is the prevailing practice. It all depends on what the other competitors are offering. It all depends.
What the other competitors are offering?
Okay, let's say, for instance, right, there are several supermarkets in an area, and they would the other supermarkets hold themselves liable for any damage you incur, or any damage that's
So
caused to your vehicle.
if they're going to compensate me, the other person should.
And no. And then you choose to go to this place. Then the court would say, well, you chose that risk. They may say that you chose that risk because there are other places you could have gone to. I'm liking
this idea of shopping at other places.
You see, it really is a question of, as a consumer, you need to know what you're getting into.
Power of your dollar,
Before you patronize at a place, you need to ascertain what is going on. If you go to a supermarket and you see there's a parking lot, and you see there's no security guards anywhere, there's no security cameras anywhere, and they have up this sign, well, that should tell you something about the person you're about to patronize. And you should make a decision for yourself not to patronize them.
I hear everything you're saying. I keep hitting against the wall because I find it so wrong. But maybe one of the things I can look at, maybe I can say I didn't see the sign.
Well, if the sign is in such a place that you didn't notice it, say for instance, you go and you park, and after you park, they give you a ticket. And the disclaimer or the exclusion clause is under the ticket, and there was nothing pointing you to it, then they can't invoke it on you. The court wouldn't allow them to.
Oh, Lord, if nobody...
You see, at the end of the day, when you enter into a contract with someone, it all depends on what you agree to. And even beyond the contract, when you enter into a relationship with someone, they have a duty of care to you in negligence. However, if they made it clear to you up front that I do not assume this duty to you, you have a choice. Go somewhere else.
Attorney Christopher Forde is my guest this morning. We're dealing with my personal lines that I'm sure a lot of folks have. If everyone has signs that say no liability, then what recourse do we have? Zero as far as property is concerned. Is that what you're telling me?
Well,
I know you say it's up to the court, but it's hardly likely that the court will, in fact, give me relief because they're going to say the sign was there.
Well, you see, it depends, I said, on the circumstances. If you go into a parking lot and you see a security guard, even though they have this sign up, then you tell yourself, well, yes, they're not liable, but there's a guard there.
So if they have a guard, for instance, and I come out and somebody broke into my vehicle.
And if, for instance, the guard left while you were there and there was nobody there, then you could say, well, yes, I know they held this indicated that they were not liable, but a guard was there. He should have done his job. If the guard left while you were there and then nobody else was there, then you could have said, well... Yeah.
As it relates to property, to the best of your knowledge, sir, is this something that suffices in most parts of the world, would you say?
I know there's a similar unfair contract legislation in England as well.
Not to confuse it, the unfair contract legislation is to make sure that I can I can correct that's...
Yes, exclusion clauses, they, as far as I know, in other common law jurisdictions, they also exist, yes.
Oh, all right. So a guy park up in there. There's a guard out there. Some guy drives through the place, wreck a couple of cars, mine included. Yes.
I'm
on the company's property, and I have no recourse. Is basically what we have said.
Well, if you agree to that, well, yes.
Okay.
I don't think you would. But like I say, it depends on the circumstances, and the court would have to make a determination.
Since I have no protection inside of here, I'm going to start thinking in terms of Mr. Rogier buying my doubles on the side of the road. Anyway, that's a different conversation. Let's get into the area of the personal liability.
No.
Now, so the sign that I saw that caused me to call you
Yes.
said, "We are not responsible." I think I sent it to you. We're not responsible for injury to you or your property. Let's talk about the injury to me while on the compound of a company I am doing business with.
Well, what the law provides, the legislation provides, is that you cannot have a clause that excludes you from liability for personal injury if it's caused by your negligence. So that is not a legally valid clause.
I see.
It's not one that would hold up in court.
So you're liable, for instance, if you leave water on the ground and I slip on it.
Of course.
You're liable, of course, if something falls off your shelf and I get injured by it.
Of course.
You're liable, of course. Oh, good. I like the sound of
Listen,
that.
you are liable if you go into your neighbor's house and you slip and fall, That extends beyond a commercial relationship. It
Understood.
extends to occupier's liability. If I am in control of premises and I invite you in, I'm indicating to you that it's a safe place that you can be in. There wouldn't be any traps, any hazards to your health. Now, if you damage yourself or injure yourself while you are there on my invitation, then you can you will have a case against me.
I still insist something should be done about that property thing. But let's continue with the personal side here.
Yes.
All right, the personal side. I am in a business. A robbery takes place. I am injured.
Yes.
Can I sue the establishment? Because my expectation of a secure place to do business.
What did you go to the place for? Now,
I went to the place to purchase bread.
You see,
But somebody came in and robbed the place. I was on your premises.
they have a duty of care to provide a safe premises for you, right? Without any inherent risks. But when you go to a robbery, that I think would be a bit too remote, because they have no control over whether or not they are robbed, whether or not people come and try to steal from them or steal from you. So I think if you had to take a case like that, you would have to show that they assumed that duty of care to you. No, let me give you an example.
No, I'm clear. I am just
Yes,
chuckling because I'm like, my jaw is hanging down. That's all. Go ahead.
Now, if you go, for instance, one of these big fats, all-inclusives, where they indicate that they're providing secured parking. Secured parking. Well, if you suffer some injury to your personal effects, your vehicle or whatever, then you can sue them.
It is explicitly stated.
Precisely. But if you go in a Chinese restaurant to buy food, the only duty of care they really have is to ensure that their premises are safe. And
I'll leave my little Chinese restaurant alone, and I'm talking about some of the big supermarkets inside of here that I see this sign on that telling me I'm not responsible for anything you do inside of here.
No.
So,
It's upsetting, but at the end of the day, as consumers, we really have a choice, and we could change the way they do business as well if we all come together and decide that we're not.
That is the reason that I thought we would put it in the public domain this morning.
Precisely.
Because, but interestingly, to find out, which is what the reason I ask you,
Yes.
is this idiosyncratic to Trinidad? Is this something that happens other places?
Of course.
This whole question that they can put a disclaimer out there.
Of course, it is. It
That
is something
is
that happens. Yes, exclusion clauses, as far as I know, it exists in the common law. I am entitled to indicate the duty I assume over you, and once you have notice of it, then you act accordingly.
Okay, so all right. First of all, so I'm clear on that.
Yes.
Attorney Christopher Forde is my guest here this morning. I'm not really drilling him. I'm really drilling the legislation here that's driving me totally crazy. But it is what it is.
But the legislation is actually quite helpful. The legislation provides you with that protection. It indicates that, listen, they cannot exclude themselves from liability for personal injury.
For personal injury, I'm clear on that.
When it comes to commercial transactions, it all depends on whether or not it's considered reasonable, and the court considers certain factors when it comes to that question.
All right. So I drive into your business place. I'm going back now to the property side of it. We clear on the personal.
Yes,
I got that.
yes.
Oh, wait a minute. Am I clear on that? Hold on for a second. So I'm going in. I'm in on your property.
Yes.
I'm about to walk in to do my shopping. I just leaving your car park. I'm about to come to you,
Yes.
and I'm accosted by someone, and I'm robbed at that point.
I think even that might be a bit too remote.
Remote? I'm robbed. That's really right here.
Yes, but I mean, did you expect to be robbed that day? I mean, could
I
be
never
really
expect to be robbed.
Well, exactly. It's something that's so remote that I don't think the court would necessarily say that it's something that the...
All right, so my property is damaged. I'm not winning with this attorney here at all. So my property is damaged.
Yes.
Can I or my attorney demand to see the surveillance cameras so at least we can get a look as to who would have done this since I'm not being covered?
Yeah. Well, you can ask, but it's the video footage.
Yeah, the video footage.
Is the private property of the restaurant owner. They, as far as I know, they have no duty to give it to you. They have a duty to give it to the police if they have an active investigation ongoing. But I'm sure there's provisions for that. But for you as a personal private citizen, they don't have any duty to give it to you. It's their personal property. What if you decide to bring a private prosecution action against someone and they need it as evidence? You could petition the court.
But I don't know who hit it. I was in your business shopping at the time. I'm merely asking for your cooperation. You were telling me it's up to the discretion of the business, and there's no way I can compel them to provide the footage so I could see what happened to my vehicle?
Personally, I don't think so. What you may have to do is bring it to the attention of the police and have them run an investigation.
Mousy tongue, I need a bicycle. I'm going to start using bicycles.
The bicycle is easier to steal it.
I'll chain it onto their gate. Maybe the security will be watching onto their gate to see what happens.
Now, this is just based on my understanding of the law and what I have found in my research.
Like I said, I'm not even disputing what you're saying. That's the reason I call you here. Law is your business, it's not mine.
Indeed.
But I find it unconscionable that you can have a situation where I am here patronizing your business and someone can look at me and say, if something happened to you on the premises, we're not responsible. But if I drive into your wall and damage your gate, I'm responsible, huh?
Don't patronize the business. You have a choice, you know.
But if it applies everywhere, I have no choice. I have to do it.
Well, then that's one of the circumstances the courts would look at. If it's something that applies everywhere.
Everybody's saying that we're not responsible.
At the end of the day, you have no choice but to park there. Then it might not necessarily be a term that you accepted. You just had to do it because it's a big commercial entity against you. So like I said, it all depends on the circumstances. As a matter of fact, when you look at the second schedule to the Unfair Contract Terms Act, that's one of the factors they considered, the strength and bargaining positions of the parties. Taking into account alternative means by which the customers' requirements could have been met. So if that's the standard thing right around, you didn't accept it. You know, it was imposed on you.
If I purchase, and this is beyond what we basically said we were asking, but I saw a case recently where a woman is suing a supermarket for the millions of dollars she incurred because she purchased something at the supermarket that interfered with her health.
Yes.
So if I come in and I purchase a product from a supermarket, a business, for instance, and I am adversely affected by that, can I sue not only the manufacturer, who I will, but also sue the business for putting it? And I'm dealing specifically in the area of expired meat and stuff like that.
Yes, of course. It's a question of what you can recover. You can't recover much more than the damage you've suffered. So even though you might want to sue both of them, you can't necessarily recover from both.
You'd be surprised some of the bills I can come up with. Anyway,
but you can see you can sue the supermarket in contract, and you can sue the supplier, the person that creates the product in tort.
You see, Attorney Forde, one of the reasons I asked you here this morning is because I just get the general feeling that folks are not aware of what they have no power over and what they may have power over. It is true to say, as you have articulated repeatedly, that you've got the power of the purse.
Of course.
And you've got the power of the purse, and I concur with that.
Of course.
But on the other hand, folks are saying, well, if I see a sign like this put up, for instance, had I not called you, I would have been, well, I mean, I'm outside, so I've seen it outside, and I find there's no way you can tell me you're not responsible for me.
Indeed.
But somebody put a sign up like that, and other people just see it, nobody would want to pursue it any further if something happened to them, and they will leave and have to pay their own medical bill and see by themselves.
This is why they put up these signs relating to personal injury. They know, or they should know, that it's not a proper sign.
So it's put there only for those who will not follow through.
But precisely. Now, you asked me an earlier question relating to whether or not you're covered by their insurance.
Yes.
It all depends. There's, as far as I know, apart from the Motor Vehicles Third-Party Risk Act, which provides that every driver vehicle must have at least third-party risk, right? Which provides protection for whether anybody apart from the driver, apart from the driver, whether you're a passenger in the vehicle or somebody inside the road who's injured by an accident. I'm not sure of any legislation that provides that these corporate entities, commercial businesses, must have insurance.
Maybe we should start looking at some of that.
Of course. In any event, if they have insurance, it must be some sort of indemnity insurance that provides for this type of liability. And people have to understand as well, they wouldn't be protected under the insurance. What the insurance, in fact, does is that it protects the insured. And the buffer it provides for the individual is that it ensures that if you are injured and the insured is liable, then somebody would pay you. There's somebody you can approach to pay you.
I hear what you're saying.
Yeah.
Attorney Forde, again, whenever we reach out to you, you're there, and of that I'm truly appreciative.
No problem.
On two sides here. One, while there may be limited recourse for property, we know there is definite recourse.
Yes.
We have established that this morning for personal injury, and there is a possibility, depending on the circumstances, that I can make a claim for property damage.
Yes.
In addition to, I hope that we put it in the public domain, that the relevant people would look at it,
Yes.
some way of piercing this safety shield, whether it be in the general insurance coverage,
Yes.
or specifically, I'm on your property and you have to take care of me.
Indeed.
I appreciate you taking the time this morning. Thank you so much. So you have yourself a wonderful day. Thank you for coming in.
You do as well.
Thank you.